people today. They could spend half their lives over 50. That's a lot of living. So it helps to have a wise friend and fierce defender in your corner. A friend like AARP. So your health lives longer.
This is just slow-mo karate?
Just slow-mo karate.
Your money lives longer.
I just bought that.
I just sold that.
And your happiness lives longer. That's why the younger you are, the more you need AARP. Join today.
Welcome, everyone, and thank you for joining today's virtual event. As a dedicated volunteer with AARP, I'm delighted to welcome you to a virtual event that's close to our hearts. Our mission at AARP is to enrich the quality of life for individuals as they age through proactive advocacy, impactful service, and the dissemination of valuable information that champions positive social change. In today's event, we're diving into the dynamic concept of disrupt aging. Disrupt aging is about celebrating the diversity of aging experiences through personal stories, images, and a variety of perspectives, fostering a community that is not defined by a single voice, but is inclusive of the many voices advocating for change. Together, we'll challenge outdated beliefs about aging and to ignite new solutions for a future where every individual can age with dignity, purpose, and endless possibilities. Let's engage, learn, and be inspired to view aging through a new lens. Welcome to this journey of discovery and transformation. We also invite you to join the AARP volunteer team to make a difference in the caregiving community.
Good morning and welcome to AARP Illinois, hosting today's class on Guardianship and Advocacy, Protecting Seniors' Rights. I'm Lori Hendren. I'm the Senior Associate State Director in Illinois with AARP, and we welcome to have you here. As you know, AARP, our mission is to improve the lives as you age and all those who are 50 plus. And today we're taking a deep dive in the conversation of guardianship, its legalities, balancing safety and autonomy, and exploring the alternatives like limited guardianship and supported decision-making. To shed light on this important topic, we have our elder law attorney, Steve Andersson, joining us. If you joined us before, he's been our guide through many of elder law discussions, and he's also a contract lobbyist with AARP Illinois. Welcome, Steve, and thank you. And if you are joining us, we highly encourage you to put your questions, comments in Facebook or YouTube chat, as this is a discussion and we want to hear from you. And we have 30 minutes to chat, so let's make the most of it. Today, we're going to be covering a broad range of topics, and they are a starting point, though, for discussions for planning and consultation. But primarily, you need to talk with your family or professional advisor in elder law, financial planning, or healthcare for more information for your needs. So keep in mind that the specifics of elder law may also vary by jurisdiction, so consulting with an elder law attorney or financial advisor is advisable for personalized guidance. We've gotten all the welcomes out of the way. Welcome, Steve, as always. Let's get going.
Thank you.
Steve, can you define adult guardianship and its primary purpose?
Yes, absolutely. And thank you, by the way, for having me. I always enjoy these. I do want to start with one comment before I answer the question, besides my cough, is that what we're going to be talking about today is a general overview of the law. We're not really talking about one specific jurisdiction. I'm in Illinois. I'm a licensed Illinois attorney, so a lot of my focus will be on Illinois, but I try to broaden this so that the answers are more generic for anyone who's listening. But that also means my answers don't necessarily apply to any jurisdiction. So that's why it's important for you to talk to an advisor in your state or jurisdiction. So with that in mind, the question of can we define an adult guardianship and its primary purpose? Absolutely. So a guardianship is the court-appointed process for putting someone else in charge of you, if you're the senior or the disabled person, putting someone in charge of your daily living activities, let's say. So this only happens in very serious circumstances. Most of the time, probably many of the listeners are familiar with the concept of a power of attorney. Power of attorney is not court appointed. This is only if we've gone beyond that, and there's a real need for a variety of reasons why we need the court to order this. And when we do that, the primary purpose is to put someone else in charge. That can be both limited and it can be on everything. What we call a plenary guardianship, where someone is in charge of everything for mom or dad or me or whoever. So the main job, if you will, of a guardianship is simply to put someone in charge when you can no longer handle those daily decision-making processes.
Okay. So then what are the key legal principles surrounding adult guardianship?
So the fundamental key principle is your ability to make decisions. So the test, and I will tell you this is Illinois, is before you can ever file for a guardianship, there has to be a certification filed by a physician saying, there's a substantial question about whether or not you can make decisions. So it's all about your capacity. If you are in your normal capacity, you're aware and oriented to date, time, place, you know who the president is, all the normal things of life, you would not qualify for a guardianship. No court would give it to you. So your rights can't be taken away willy-nilly. But the principle is, if you no longer are oriented to time and place and date and who the president is and a variety of other tests where you can't make those decisions for yourself, that's the key principle. The second key principle, though, is if that power is granted to someone else, the job of that guardian and the job of the court is your best interests. It's not about anybody else. It's always going to be about you, and you always have the right to question that. In other words, you can always say, I want to go back to court. I want another chance to prove that I'm still capable of doing this. So two most important principles: your capacity. Second, your best interests.
Okay, very interesting. So let's talk about how guardianships impact someone's autonomy, personal autonomy. That's huge. And I've heard just the other day in the Capitol about scenarios where people are basically advertising guardianship at people at point of care crisis, saying, hey, we can do this for X amount. A lot of scariness out there. So in the best scenario, what does it mean for someone's autonomy when you allow someone to be your guardian?
Right. And again, this is more extreme, right? We're talking about a circumstance where powers of attorney won't do it, where voluntary actions won't do it. And we can talk about why. But when you say best, I hesitate to answer best because it's maybe not best, but it will be okay. So for example, there are things called limited guardianships. So let's say that you have physical limitations, but you don't have mental limitations. There can be a limited guardianship that says you need a guardian to help you with mobility issues. Maybe you can't use a computer anymore. Maybe you can't use a phone anymore. So you need someone to help you with those things, but they're physical in nature. You get to retain all of the decision making, but you need somebody to facilitate that. On the flip side, let's say that you are suffering from something that impairs your ability to make certain types of decisions, mental conditions. A court can say, I'm going to appoint a guardian to do X, Y, and Z. But if it's not within X, Y, and Z, you, the person with the guardianship on you, you still have the ability to do everything else under the sun. In other words, the court can just say, there's just a few things. So that's maybe the best, if we talk about best, where it's very narrow what you need the guardianship for. And I'll go to the furthest extreme. I don't want to call it worst, because it might be the best thing for you. But the most extreme is that the court says, we're going to order a plenary guardianship, which means all decision-making power is removed from you, the person with the guardianship, and given to someone to be your guardian. And so in that case, they make all the decisions for you. But that's extreme. That doesn't always happen.
So, what is the measures, and I know you're licensed in Illinois, what are the measures in place to balance the safety and the autonomy under guardianship for someone?
Right. So, because it is such a powerful tool, there's actually quite a bit of balancing that goes on. So, first, like I said, the first threshold to even a court even considering a guardianship is there has to be a certification from a physician, a licensed physician. So, it's not like you can go in and ask without that. So, that's that first
Okay.
threshold is someone in an objective way is saying, yeah, this needs to be considered. But that's only step one. Step two is then, excuse me, when the court hears, let's say, the first hearing date of your case, when the court hears that, the court will likely assign what's called a guardian ad litem to you, to the person who's needing the guardianship. That person's job is not to work for anyone but the court, to give them the best advice that they can, interview you, interview family, interview everyone involved in the circumstances to create an objective decision as to whether or not this is really needed. And then three is, let's say the court is still not certain. The court can then hire other medical professionals to decide to get a further evaluation of you to see if it's really necessary. So there's at least three stages there. And then, of course, the fourth is the judge himself or herself. Their only job, like I said, is your best interest. And so their job is to decide objectively to the best of their ability whether you need it or not. And then also, once they do that, the decision is how much of a guardianship does the court award, if they're going to award one at all. Limited, like I said, kind of that least case, to the most extreme, a plenary guardianship where all powers are given to your guardian.
Wonderful. So, I'm going to go to this question. Who pays for the guardian ad litem? Is that someone that the individual who is to receive guardianship? Is it the person who wants to become guardian? Is it a cost that's bared upon government?
So a little bit of both or all, I suppose. If you have an estate that has the financial ability to pay for these expenses, your estate will pay for it because it's we're doing it for the best interests of you. So it's appropriate that your money is used for it. You may not agree, by the way. You may be the person who a guardianship is being sought for, and you may not like it. So that is always an emotional question. But if the guardianship is granted, then it's likely it'll be your funds. But let's say it's the other circumstance where you don't have much money and you can't afford any of these things. Then the court will have the state pick it up effectively.
Okay. All right. So we have, thank you viewers for joining us. We do have a question right now in YouTube. Solo ager, great way to phrase it. I can't afford a trustee or lawyer. Other suggestions, really, as they're going through this journey and need assistance. Where
Sure.
does someone go?
Yeah, that's an excellent question and a common one. I would suggest that if you can't afford an attorney, there are pro bono attorneys out there. Pro bono meaning free. It's Latin. We're lawyers. We like to pretend we're fancy. It just means a free volunteer attorney who's willing to help you. There are organizations that provide that help. In my area in Northern Illinois, there's a group called Prairie State Legal Services that you can Google, and they provide that sort of information. And if they can't help you, they might be able to point you in the direction of someone who could. I also know that there are regularly what we call pro bono clinics where private attorneys volunteer their time, typically like at the court law library, and you can go in or you can do it virtually and you can talk with one of them. So those are opportunities that do exist. And you can Google your local bar association. I live in Kane County, Illinois. So you could Google the Kane County Bar Association, for example, if you're in Kane. And then you can call them and say, I need help. How do you recommend I go about doing something like that? And most bar associations will have resources that they can give you. So hopefully that's some of it.
Yeah, no, that's wonderful. We have a follow-up question on guardianship. Great question. Does guardianship last after the person is deceased? And if so, what else is needed?
So great question. Typically it doesn't, because you don't need a guardian after you're dead. I mean, let's be honest. Similar to powers of attorney, they're only for your lifetime. But I will say that it is common for there to be a wrap up. In other words,
Okay.
if the guardian, you have let's say you have your final expenses and things, and then a funeral and a burial. A lot of times those things are empowered within the guardianship as well, just to wrap up. But
Mhm.
remember, if you do have a will or a trust, and you pass away under the guardianship, your will or your trust will still be honored. It's not like the guardian gets to
Oh,
change your
okay.
mind, about what you
Okay.
want. So your wishes will still be honored.
Yeah, that's a great because my next follow-up question was, does the guardian have basically rights to your finances, right? To be able to spend, or I mean, to be able to pay bills on your behalf, or to be able to use the funds wherever when you are living and when you pass. And I think, am I hearing this correctly? It goes back after you pass to your will. Is that
Right,
correct?
right.
Okay, but then
So
when you're living, what happens?
So during your lifetime, yes, if it's the more typical guardianship, which is generally that guardian is going to be appointed to take care of your finances, for example, they'll have access to your bank accounts and be able to spend your money, but not for them, just for you. If they spend it for anything other than you, they're committing a crime, and they should be punished for that, and they would be removed as your guardian. Um, which, by the way, I want to throw this out. Even if you have a guardian, it's important that other people are aware of your circumstances. So if you have friends or family,
Mhm.
they should be strong advocates for you too, and be in touch with the guardianship and kind of keep an eye on what's going. Not everybody will have that, I understand. But where possible, it's good to have some um, advocates, personal advocates, to keep an eye on everybody. It's never wrong to
Mhm.
have that. I think I may have
Great.
lost
We
track
got
of the question when I said that. So,
No, you're right. We're getting great. Thank you for all that are joining us. We're getting right to your questions with Steve here when our limited time. Facebook, great question. Can more than one guardian be defined?
no, there will be one guardian because the court appoints the guardian. So there'll only be one. But if that guardian, for whatever reason, can't continue to serve, or let's say you're dissatisfied with that guardian, you could then instead go back to the court, because you always have the right of access to the court. You, as the person with the guardianship on you, you could go back and say, I'm not happy with this person, or this person's left. Then a new guardian can be appointed if the judge agrees. Remember, at this point, it's up to the judge, not up to you. The judge will listen, but ultimately it's up to the judge at that point. And remember, all of this is when you no longer have a lot of capacity. If you have the
Okay.
capacity that you have right now as you're listening to me, there will be no guardianship. If you're capable of listening and living independently now, there won't be a guardianship.
Interesting. So there's one more great question that I was going to ask too. Is a guardian responsible for any debt of the person under guardianship?
No,
Great
the
question.
guardian, no person would serve as a guardian if they were liable for the
Mm,
expenses of the person they're responsible for. So no, they are not. It's your estate. And then let's say you run out of money. Then Medicaid would likely pick up, the expenses of any nursing home care, if that were the case. And the Office of the State Guardian or the Office of the Public Guardian, state and local, will pick up the expenses of the guardian and guardianship.
okay. Let's get back to our questions. What are the responsibilities and limitations of a guardian? I think we may swing back around some of the stuff you've already spoke to, but let's go back to it. What are the responsibilities and the limitations of a guardian?
Okay. So the responsibility, like I said, is fundamentally your best interest. So if the guardianship is appointed to take care of your financial circumstances, for example, their responsibility is to spend your money wisely for your best interest, not spend it, frivolously, and to keep your books balanced, to do all the things you would have done in the past for yourself, to make sure that you're living the best life possible, managing your money well, taking care of it. Those are the responsibilities in that circumstance. The limitations, on the other hand, are whatever the judge might impose. So, for example, if the judge says, you can manage the money, but you can't invest it in the stock market because maybe at that point the stock market is, volatile or something like that. There are whatever restrictions that the court might impose. And remember, if it's not a plenary, complete guardianship, if it's a limited guardianship, the court's going to say what the guardianship is about, and anything that the judge doesn't say, you retain those rights. I'll give you an example. Let's say a judge gives you a limited guardianship, says it's all about finances, right? Nothing but finances. You meet a person and you want to get married, right? You have the power to get married. That's not been taken away from you. You have the power of mobility. That's not been taken away from you. You have the power of free speech. That's not been taken away from you. Only the financial things. So that's just one example, or I guess 3 examples. Things that could be still part of your power.
Okay. We have another great question from you two. Keep them coming, folks. This is wonderful. How do we deal with a person who is misusing funds of an elder person, especially if the elder doesn't know how to handle finances under this guardianship?
Sure. This is a terribly serious and important question because I wish I could say that it doesn't happen, but I think we all read in the newspapers and hear about it that it does happen. So it's a very serious question. Number one, if you have evidence, you believe you see it happening with a friend, a neighbor, a relative, the first thing that you would do is try going to the court. Go to the court where the guardianship is at. Excuse me, because again, the court is always having jurisdiction over your guardianship, so he or she can always reconsider what's going on. But maybe let's say you don't have access to that. You don't really know how to do that or what that is. You can go to your local state's attorney as well in the county in which this is happening. And you can report this. And you can say, hey, I have a problem. If that doesn't work, you can go to the office of the state guardian, and the Department on Aging has an ombudsman's office. And the ombudsman's office is another place that you can go. And you can report this, and that's what they do. They watch out for people. So there are many options for that. But the one thing that has to happen is somebody has to ring the alarm bell. So don't be afraid to do that. As long as you have don't do it, don't misuse that. Don't think something's wrong, but you have absolutely no evidence. But if you've got some level of information, and I don't mean like court evidence, I just mean, normal people, I see spending that just doesn't make sense. I see a caregiver who's driving around in a brand new car or something like that.
Mm-hmm.
That's what I'm talking about. Don't hesitate to try one of these routes.
So great. We have great questions coming in. I'm going to go to the next
Excellent.
one. I have a parent with memory issues who lives out of state. Can I request guardianship if I'm in state A and they live in state B?
Yes, you can. You would request it in the state in which they live. So if you're in Illinois and they're in Nebraska, you would ask a court in Nebraska to do it. But I will say this, don't immediately jump to guardianships. We're not talking this time about powers of attorney, but there are a lot less intrusive ways of helping a person who needs help. And so I wouldn't automatically just jump to guardianships. I would explore some of those lesser power of attorney type options.
Wonderful. So here's the next one. What if we're incapacitated but have no family or friends who are willing to act as our guardian? What happens?
Then a public guardian is appointed for you, and the state and the local county, at least here in Illinois, it might be different in other states, have people who are paid for by the state to administer your guardianship. There are also private guardians, banks and things like that that use that. That would, of course, only be if you had money. And I worry about those, to be perfectly honest. I worry that they're not doing it for the right reason, that they're doing it for money. So I would be cautious about that. Best is, of course, family and friends. But if not, then I would say the state or the local public guardian.
So we have a individual who resides in a nursing home. Loved ones are in other states, so they don't visit very much. Can nursing homes become guardians of that individual if they think it's necessary?
They can petition for the guardianship. They should not become the guardian. In my opinion, that's a horrible policy because there's an immediate conflict of interest, right? Because they get to decide your financial condition and they're also being paid by you. You know, your estate is paying for their care.
Mhm.
So that to me is an immediate conflict of interest. They can say you need a guardian and they can even initiate the proceedings, but they don't get to be the guardian if I have anything to do with it. And I think most judges would
Sure.
agree.
Yeah. So let me ask you this: when we talk a lot in our work in Illinois when someone is at a point of care crisis for the caregiver, and their loved one has to go into long-term care, and you have to sign all of these forms, right? Is this something you kind of got to take that pause and really read over the forms, making sure there's no, frankly, a sneaky clause or something that shouldn't be in there that gives additional rights to nursing homes to start executing or act as? I mean, am I speaking out of context here, or is this something that caregivers and loved ones just got to, at that very hard time, take that extra moment to focus and try to get through the forms?
Yeah, great question. Um, and the problem is the forms are complex and they're written in legalese, right? So even if you are
Right.
reading them all the way through, you may not necessarily pick up on something. These are called contracts of adhesion, which means you either take it or you leave it. You know, they don't typically say, "Well, we'll negotiate what our contract is." So the best I can suggest on that, and I'm thinking of the time point that you're at. You know, you the
Hmm.
family is you got to make decisions maybe in hours or days.
Hmm.
It won't be weeks or months. And I've done this. I mean, I've lived through it. And even though I'm an elder law attorney, I can tell you it's a crisis, you know, and it's a panic even for someone who, you know, in theory knows, you know, a great deal more than most. So it's not easy. Do the best you can. The reality is there are a lot of state protections. I can't say that for every state, but I believe it to be true for most of them, that there will be ways to get out of a contract if you are dissatisfied with it. That gives you a little back end time to
Okay.
consult with an attorney or financial advisor and realize, oh, I don't think we made the best decision. There's a lot of ways to get out of it that have been built by statute so that you don't have to worry about negotiating that in a time of crisis. Ultimately, it will be okay. You know, these are serious
Mhm.
times, serious questions, but as long as you know you have family or friends who are diligent, that will definitely do it. And also, it's great to have family and friends who are nearby a nursing home because
Mhm.
then they can show up unannounced and visit and see what circumstances you're living in, which is terribly important because if nobody ever visits, then uh, then the nursing home gets free reign. So it
Mhm.
can be done, and it can also be done even without family and friends. But you have to kind of plan in advance. Hopefully, have powers of attorney, someone who will help.
Yep, no, thank you. And I bring that question up because I too had a loved one. My mom was placed in a facility, and even as an employee with AARP who has the privilege of working in this field, though not an attorney, I took the time, and there were some things in there that I could be able to jump back and say, but at the same time, there was multiple family members involved, so there was a little more balance of stress, at lack of a better term, and that's not always it. When you're at a crunch, you need to get care for your loved ones. So, but
Right.
my goodness, we are already at a half hour. We could not have done this with all of you that have been joining us today, offering great questions on YouTube and Facebook. And on behalf of Steve and I, we want to encourage you to write some topics in there which you would like us to work together and deliver to you in the coming months. So we look forward to having that. We want to thank you for, obviously, Steve, for joining us today. You're always fabulous as an elder law attorney here in Illinois and also a contract lobbyist who, with ARP and myself, we specialize in nursing homes and um, home care and providing the best possible environment and community for someone to age in the setting of their choice. So we thank you. If you're looking for more resources on caregiving, You can find valuable information with your local department, your state's Department of Aging, or visit AARP at www.aarp.org/caregiving. An abundance of resources there for you during your caregiving journey. Please take advantage of these. They're free, but they're here to help you navigate. Again, www.aarp.org/caregiving. We even have a prepare to care guide if you're in the midst of caring that you can click a button and we're going to ship you that book for free because we support you in your journey. So once again, thank you all for joining us today. We look forward to continuing our mission of supporting seniors, caregivers, and the entire aging community, not only in Illinois, but across the nation. Have a wonderful day. And this concludes today's virtual event. Thank you.